have my phone right here and you can text me.
Karen's not on yet.
Okay. Good morning, good morning. We are broadcasting and recording today for the LT Senior Seminar Series, and it is June 1st. Oh my gosh, who would have thunk? It is already June 1st. It's amazing, isn't it? Welcome, everybody. We're just letting people log in. It is 10:30. We'll probably just wait about another minute or two, and then we'll get started. But we're so happy to see everybody here today. We have a great topic that we're going to be talking about, and we have some events coming on this week that we're excited about too. So, hey, Karen, she's going to come on to say hi too. So without further ado, let's go ahead and get started. My name is Cindy Cummings. I am one of the founders of LT Senior Services. We are a nonprofit and we help seniors in the Lake Travis area. Our mission is we were designed as a Lake Travis resource to serve and engage aging adults and their families in the community. So one of the things that we do is we offer these webinars. Actually, they used to be seminars way back when at the library. And then we had also added doing seminars at the activity center. So instead of having those seminars at those locations, we've gone online and we are now doing webinars via Zoom. And we welcome you all here today. So this is LT Senior Services. We have a special event coming up this week that we know everybody's really excited about. Who has a ton of paper as they've been going through all their file cabinets? I do. So we are having a shred day, and it's going to be low, no contact shred day. We're super excited about it. It's going to be Thursday. It's from 9 to 11. It is a fundraiser for LT Senior Services. We're just asking for non-perishable food, maybe some money that we can use to continue to help feeding seniors in the LT Senior, in the Lake Travis School District. And we've been helping lots of seniors who are shut in. It's not only financially that these seniors can't get the food, but they just physically can't get to the store to get food too. So we've been working with lots of different nonprofits in the Lake Travis area. We're happy to be partnering with them. We'll have another what would you call another wave of food donations after our event on Thursday. So we're super excited about that. It's actually being held with Lakeway Aquatic Center, and they are located on 620, and they're close to the Wells Fargo there on the corner of Lakeway Boulevard and 620. You can't miss us. We're gonna have a big shred truck there. You pop open your trunk, we'll get the paper out for you, and we're super excited about that. So that's one of our events that's coming up. We also have some members on the call today. I'd like to introduce them just real quickly. First, we have Karen. Hey, Karen. And Karen's with the library. She's one of our members of LT Senior Services. And Karen, tell us what's going on with the library right now.
Yeah, thank you, Cindy. Thank you, Natalie. The library opened for curbside reserve pickup last week. So we've been getting a ton of returns, and basically you reserve your items on the catalog and then you call us between 10 to noon and 2 to 4 Monday through Friday and 12 to 2 on Saturday and Sunday. And then you drive through the parking lot and then give us a call and we'll check out your item and put it on a table outside the doors of the library. And then you can come out of your car and pick it up and pick up the item. So we are offering services, the curbside reserve pickup.
Wow, Karen, that is a ton of work for y'all. It's so nice that you're going to that extra effort, but I do know that people really depend on the library, you know, as a source of information and entertainment, and we all need a little bit of entertaining. Right now, Netflix is getting pretty low, seeing a lot of those shows on Netflix, so that is awesome that you guys are doing that. And you were, on Thursday, you can't come because you're doing story time, is that right?
Yeah, we have today starts our summer reading program actually. So we have an application called Beanstack where we're hoping if the whole community reads 100,000 minutes, our Friends of the Library will donate food to the 2 local food banks, Lake Travis Crisis Ministries and Helping Hand Crisis Ministry of Spicewood. So if you get an application called Beanstack, you can log all your reading and then all those minutes will contribute to that. And then we've got origami on Mondays, 2 story times Tuesday and Wednesday. We have performers on Thursdays and a book talk on Fridays. So we have summer reading is kicking off today.
That's exciting. Well, and you've been helping some of our participants of the webinars with their technology issues too. So that's super cool that the library will help people with tech issues. And I understand you can call in for tech help. Is that right?
Yeah, you can also email techcoach@laketravislibrary.org and they'll set you up with a one-on-one person. And we also have tech coach on Wednesday mornings also with Miss Raj and Miss Catherine.
That's excellent. Thank you so much, Karen. We just love being
Thank you,
your
Cindy.
partner through this pandemic. It's been super fun, huh? Learning how to do things a new way. Hey, Ray, we're going to come to you next. Tell us a little bit about your business and what you do. And then if you want to, go ahead and tell us about the upcoming seminar.
Yes, Cindy. It's great to be with you this morning. I'm Ray Daniel. I live in the Lakeway area. I'm with Fairway Independent Mortgage. I help seniors to age in place, which is what we've been doing for the last 90 days. We've all been aging in place, unfortunately, but by using the equity in your home, we can allow you to fix up your home so that it can be the place that you want to stay for the rest of your life, if that's what the situation is, or if your home's not where you want to be for your retirement years, then we can help you to buy a new home with a reverse mortgage. So those all are ways to help you age in place, as well as making home improvements and other things that make your house safe for you to live there in your 60s, 70s, 80s, 90s, and early 100 years. So we'd love to have you on the call next week.
Right.
Monday at 10:30, right?
Great. Yes. And it is aging in place is the topic. So we're going to give you some tips and tricks to help you make your home safe and also help you to plan for the future, to have you have projects that will allow you to stay in your home in your 90s, let's say if you're 60 now. So we're excited about that seminar. Natalie, if you'll go ahead and unpin Karen and Ray and you, and do you see any other panelists that are members that we might want to introduce? She's just looking through our list. And you are on mute, so we can't hear you. So,
Sorry, I do not. Oh, Chantel.
hey, Chantel, you want to say hey? Go ahead and bring her in real quick. It takes a minute. Have you guys been watching the Saturday Night Live Zoom? Zoom things that they're making so much fun of Zoom calls. It's hilarious. Hey, Chantel, it's kind of scary to just say, hey, you want to come into a call, but you are here. Do you want to just tell us a little bit about what you do?
Yeah, sure. Thank you so much. Seconds here. My name is Chantel Gonzalez. I'm a financial advisor with Edward Jones Investments. And as you can imagine, my job in partnering with my clients is really to help them organize their wealth, build their wealth, protect their wealth, and transfer their wealth, which I think is a lot of what Kay is going to talk about today. And really just in the last 8 or 9 weeks is really helped guide. I've really helped my clients guide them through a lot of the fear that is in the world today. So, you know, I am a true partner with my clients in all aspects of the word partnership. So I'm located in the Craigos building here in Lakeway, and thanks again. I'm honored to be a part of this organization. Thanks, Cindy.
All right. Thank you, Chantel. Okay. Without further ado, I'm going to introduce Kay. And Kay, she practices law, enjoying her 4th career. Besides teaching elementary school 100 years ago, I don't think that's probably true, Kay, but we'll give that to you. She taught international cooking at an Arizona college, and she owned and operated a bed and breakfast near Sedona. But it was clear her role as birth mother to 1 child and adoptive mother to 4 others that motivated her to become an attorney. Lively specializes in estate planning, including wills, trusts, and probate. She finds that her clients appreciate an attorney with so much life experience. I got a chance to turn into a human being before becoming a lawyer. She says her tagline, wills written at your kitchen table, reflects an extra service that she offers. So welcome, Kay. We're so happy to have you here today. And Kay, did you want me to present your PowerPoint or did you want to pull it up?
If you could pull it up when I get there. I want to introduce myself and talk a little bit first.
Great.
All right. Thank you.
It's all yours. Go
Okay.
away. Go for it.
I'm on, huh?
You're
Okay.
on.
Good morning. I am Kay Lively. I'm a member of the Lake Travis Senior Services, and Cindy, who's been speaking, Cindy Cummins, was our organizer, and she invited me to speak, which I appreciate. I'm a first-time panelist or presenter on Zoom, and so I hope you'll be patient if I get off in the weeds here and there. I work from home, so you may hear my crazy and wild, adorable rescue dog, Otis Lively, but I'm sorry about that, but I do have him outside, and I hope he doesn't interrupt us. Our topic today is stop stalling and get your estate plan in order. My topic will be more on how to preserve your assets as opposed to earning assets, as Chantel was talking about. It's really easy for us to put these kind of decisions on the back burner, but this pandemic has given people time to think about their life. That is a silver lining of the pandemic. And I've just been overwhelmed with calls, believe it or not, because people are interested in this topic. It's just that it's so easy to put it back and try to ignore it. And there's some reasons for this, and we'll talk about that in just a minute. I wanted to outline for you what you can expect to see and hear today so that you can know that whether this is really for you or not. I really think it's for everybody. Number one, we'll talk about some of the excuses why people do choose to put it on the back burner and ignore their estate planning. And then we'll have a short PowerPoint or slideshow. And then I'll ask a few frequently asked questions that I have heard in the past. And then if we don't cover what you're interested in and you want to ask, then Cindy will call on any of the attendees who will just, if you'll just raise your hand and wave at her, she will call on you and unmute you so that you can ask questions, and I'll be happy to answer you. So let's first start with some of the excuses that I have heard anyway for not to do estate planning, why people keep putting it off. I don't want to think about dying. Well, I hate to be the one to break it to you, but you are going to die someday. And so it's better to be planned and have your wishes carried out as opposed to some probate judge deciding what is going to happen to your assets. I've heard, I'm not old enough to need a will. Well, any Austin residents who drive on Mopac or I-35, you know if you're 18 years old, you need a will, at least, at a minimum. I don't need an estate plan. My wife and kids are going to inherit everything I own. Well, that may be your goal, but just saying that is not enough to cause it to happen. It has to be in writing with a couple of witnesses and a notary, and a professional attorney is the way to go. Someone who specializes in estate planning, so that you, as opposed to someone who practices many areas, I think you'll get a more expert person to advise you. I've heard of people say, well, I can just leave it and let my spouse decide everything after I'm gone. Well, it's too late then, and you're leaving a nightmare for your loved one. Estate planning is for wealthy people. I know before I became an attorney, I thought of an estate as being a mansion on the hill. And that is just not, everybody has an estate, whether it's large or small. And you need to plan as to where you want those assets to go. And it could increase in the future. Estate planning is too expensive. Well, some people think you can't afford to do estate planning. Well, you cannot afford not to do estate planning because it's much more expensive when you do wind up going to court, when your estate goes to court with an attorney, if you have not made those plans and prepared a will or a trust. So let's bring up the PowerPoint presentation now. Cindy?
Okay, I'm working on it. Hold on one sec.
No worries.
Okay, I'm not able to do it. Natalie, can you pull it up, please? It's saying share screen disabled. It'll just take us a second. Can you hear me, Kay?
I can.
All right. We don't hear a dog barking yet, so.
I have his bark collar on him that sends out a little odor that he doesn't like if he barks.
Oh, no. So Natalie's going to go ahead and share the screen. And what we'd like to do is for people to go to the chat box. And what you can do is go towards the bottom of your screen. A chat box will come up. And this is where you can type in questions here. And we do have one question. And while we are pulling up the PowerPoint, why don't we ask this question, if that's okay?
Certainly.
And you might be covering this. If you don't mind, we'll go ahead and answer this, though.
I don't mind.
What are some instances in which your estate will go to court?
Well, if you have a trust, there's no need to go through probate. But if you have a will or you don't have a will, in either of those cases, it will have to go through in order to get the deceased person's name off of the deed. If for like a married couple, if one partner dies, the other one wants to be able to sell that property eventually, and you can't do it because the deceased person's not there to sign it if they're on the deed. Same thing with vehicles and other assets.
So if you have a trust, you won't go to court. If you have
Right.
a will or you do not have a will, you will go to court.
Yes.
Okay.
Exactly.
So I believe that I'm seeing it right now displayed. Thank you, Natalie, for doing that. We have the PowerPoint up. It's estate planning and it has case information here. And Natalie, will you go on to the next slide?
I can forward it if you want me to.
There you go.
Would you rather I just forward each slide, or would you rather Natalie do it?
I think that you can. I think that since she pulled the
All right.
slides up, she needs to do it for you, and she'll guide you through it. She'll be able to do it well.
Okay.
Okay.
So estate planning includes all of these areas. Each one of these has its own code: wills, taxes, insurance, property, trust, and probate. I am not such an expert on taxes and insurance, so I'm going to leave those alone today and just talk about wills, property, trusts, and probate. Some of the terminology that you need to know about in understanding the difference between a will and a trust is that a testator is the person who the will is being written for. It only occurs and only takes effect after death. And as long as that person is living, they can make any changes that they want in that. With if it's a partial change, it's called a codicil in a will. But you can completely replace the will and just revoke the previous one if you want to. Whereas a trust, instead of being called a testator, the person who is writing their own trust, and of course with the assistance of a professional, is called a grantor or trustor. And when all of their assets are put into the name of the trust, that is called funding the trust. Now that person will be the trustee as long as they want to or are able to be. But they should name in their trust people to succeed them, so that, let's say that they become very old and just don't want to do it anymore, or they pass away. You don't want someone who can distribute those assets. And so that would be the list of trustees. And I recommend that you have one person at a time, no co-trustees, because what if those two people disagree? You could wind up in court forever and never get this distributed. Some of the types of trusts that you might have heard of are some of these. The problem that's confusing is that sometimes different attorneys are in different states. They use different titles for the same trust. But these are some basic ones that I thought you might be interested in hearing about. The one that I usually deal with that's most common is the revocable living trust, which also can be called a family trust. And the main thing about this is that it protects your privacy because it never goes to court, never goes to probate, and you save the money of not having to go to probate. A minor's trust is not a separate document. It is part of a will, and that is where you name a guardian or trustee for your children, or if you are in charge of your grandchildren, whoever, any of your dependents. They cannot inherit until they're 18, and so you need to name someone who will manage their assets, and who do you want to be their guardian and take care of them. If something, God forbid, should happen to both parents, Who would you want? And again, I recommend name a list of people, at least 3, one after the other, rather than being named at the same time, because what if they disagree on something about the way that the children are to be reared or financially taken care of? Special needs trust is like if someone is handicapped or has special needs, as we call it now. You don't want them to just inherit a chunk of money when you die, because then they are not eligible for government benefits. And then a charitable trust is pretty self-explanatory. It's just if you want to benefit your favorite charity, you can have money coming back to your heirs. There is a way to do that and still be able to give money to your charity. So I think I skipped a page. Just a minute. Okay, what is probate? So you may have heard the term and wondered, well, what exactly goes on with that? Well, the first step is that the original of the will has to be filed and then proven to be either valid or invalid. There are 202 requirements for a will to be valid. So that tells you one reason why you need professional help. People sometimes think they can do it themselves. I don't recommend LegalZoom, not because I'm trying to get more money or get your business, but because often those kind of documents are not Texas specific, and you don't understand the consequences of some of the choices that it asks you to make. And so you need guidance. You need an attorney who will actually be an advisor to you too. If there is no will, what will happen, and we'll talk about this in just a minute more, is that if you don't have a will, Texas will write a will for you. It's in the law as to where your assets go, and it may or may not go the direction that you want it to go. Wherever the person lived at the time that they died, where they had a permanent residence, that is the county where the case would go to that probate court. And the first step that would happen is to go through that process of going through probate. The judge names someone to be the executor or the administrator. And the first thing that person does is to pay off all the debts and taxes. And then whatever is left over, they can transfer the property to the beneficiaries. And there are more individual steps in between there. It's more complicated than this, but those are the basic ones. So you may have heard of the terms of executor and administrator, and you don't know what the difference is. An executor is someone who is actually named in the will. The testator named that person. In Texas, it's important that you have that word independent before the word executor, because then he does not have to check with the court every time that he goes to sell something or invest something or distribute something. He doesn't have to check in with the court. A dependent executor has to do that. So it's important to have that word independent. So if you've already have a will, go and get it out and look and see if it has the word independent executor in it. Now, let's say that the person didn't have a will, or their will was proven to be invalid, then the court has to follow state law. The administrator has to follow state law and the court's direction if there's no will to guide them as to where they wanted their money to go.
Okay, we have a question for you.
Yes.
What if the person last lived in a nursing home in one county but had all their property in another county? And the same could be true for state too.
It's wherever their permanent residence is when they pass away. So
Okay.
Perhaps they have a home that they intend to return to. That would be their permanent residence. If they have moved into that assisted living and they're never going back to that home, then that would be the county where their case would be held.
So if you had not, let's say, for example, sold the family home yet, and that person had gone into nursing care and then they passed away, it's not where the nursing care home was, it's where their primary home is.
It depends on whether they intend to go back to that home or not. If they have the capacity that they could possibly go back to that home, then that would be the correct county to go to court.
If they had passed away, I mean, they passed away. So,
Okay,
if
but
it, okay, so in this particular question, this person is saying they won't return to home.
okay, then it would be the county where they were living at the time that they passed away, where the assisted living was.
Okay, very good. Thank you. Appreciate it.
Certainly. We can move on with the
Okay,
slide.
next slide.
So if you were asked to be an executor, well, you might wonder how complicated is that, and what kind of things would I be expected to do? The first step is that the attorney would file the original will with the probate court and open probate and name the person who would be who is listed first in the will to be the executor. Now, let's say that person declines to serve, then it would go to the second person, and the attorney has to explain to the court why that first person is not going to serve, which is not a problem. It's very acceptable. The second step would be to notify all of the heirs and creditors and even the public of the death of the person. And the way that the public is notified is those little ads that you see in the paper that are in tiny, tiny font that nobody can read. That is legally, that is saying you had your opportunity to claim that you were an illegitimate child, or you can claim that money was owed to you. And so you're notifying the public, and so they can't complain later if they didn't come to court and make their claim. Then the next step for the executor would be to inventory all of the assets and take whatever they have, maybe sell some of the things, pay taxes, bills, and particularly funeral expenses. And then whatever's left over after the dust settles can be divided, going to the beneficiaries in the percentage that the testator had named in his will. So then after you go to court and everything is distributed, then the executor needs to give a report to the court, and they have an accountant who checks on everything to be sure that the assets were distributed correctly.
Hey, I have a question for you.
Yes.
Are there any duties of the executor before the person passes away, or would you say that most of the tasks are after they passed away?
They're all after they pass. The person who is, before they die, they still have authority over all of their assets, and the executor has nothing to say about it. And it actually, even after they die, they're not the executor until the judge says they're the executor. So it's important for you to get to court and get named as executor so you can start doing all of these tasks.
Okay. There's a good software package for inventory. I wanted to just let y'all know about it. It's called Fair Split. They have a free version that has reduced capabilities, but it can work for most families. I remember going through this with my mother-in-law and having to do a spreadsheet and writing down all the different items and what the values were. So you could try that particular product. It's called Fair Split. They have upgraded versions of it if you want the people who would be getting the items to be able to go in and, in a sense, do like a bidding or get the items. So it's kind of an interesting way to do it. It's called Fair Split, and I guess they think it's a fairer way of splitting items. So just FYI.
I see that we have a very good question for Sarah, who's attending today. She wanted to know what prevents the executor from dipping into the funds himself. Well, first of all, hopefully the testator has chosen someone who's very trustworthy, that they would just be willing to allow to be on their checking account, for example, someone who is that honest and trustworthy. But if they did do it, the beneficiaries can sue them and recover it. They are personally liable for any mistakes they make too. Let's say that the land's worth $400,000 and they sell it for $250,000 simply because it's easier and they don't want to be bothered to have to take the time to get the land sold for the full amount. They are personally liable, and the beneficiaries can sue them.
Can they be paid? Can an executor take payment for work?
If it's in the will, usually in
Okay.
the will, you can state either that they are to receive nothing, and often if the children are the beneficiaries and the children are also the named executors, then they'll have no payment to them because they're going to get money from the inheritance. But let's say that a neighbor or a friend is going to be the executor. Often they'll say, whatever my estate is, at my death, pay 1% to that person or 2%
Okay.
off the top. And definitely all of their expenses are covered.
Right.
So let's say that they're from out of state and they have to fly in. Well, their flight would be covered.
So to what extent do you have to inventory items? For example, at what value? How small or how large of an item do you have to inventory?
Oh, like furniture would be a category.
But does it have to have a value of $10 or more or $1,000?
There's no legal requirement on that, but typically we want in round figures. We don't put it down to the penny, but the value of the house according to what the Travis County Appraisal District says that it's worth. You can just put that down. The value of the cars if you were to resell them.
So it's not plate by plate or spoon by spoon. It might be
No.
under household items.
Yes.
It might have
Exactly.
$5,000 in household items or whatever.
Household furnishings, yes, a lump sum.
So this other question is, what if one sibling is doing all the executor work? That's typically the way it is, isn't it? There's normally one person who is the executor, and
Actually, you're right. That's a very good question. And you do want it to be one specific person who was named in the will. And that person should do it and not be interfered with by the siblings or other relatives, whether they're inheriting or not. That person makes the decisions.
And the question is, can they get paid? And I think we already answered that, yeah, you could get paid as long as it's in the will that they would get some kind of compensation.
Yes.
Okay, so we've got some more questions. Do you mind if I ask them?
No.
Okay, so the question is, do joint bank accounts go through probate? That's interesting. So I would assume if there's a husband and a wife and they're both on the bank account, do you have to go through probate?
The bank account would not have to. If they're joint owners of that account, then either one can take all the money out at any time.
Okay.
Likewise, insurance goes outside of probate. If there's an insurance policy, you have named beneficiaries on a beneficiary designation form. Also with investments, there's usually a beneficiary designation form. And there should be, hopefully, if you have a good counselor. So the money just goes to them directly rather than going through probate.
Great. If there is a pay on death clause, does that have to go through probate?
No.
Okay, so what would an example of pay on death clause be? Would that be an investment or?
I think they're talking about an investment or insurance.
Okay.
Or
If
a
it's
retirement plan.
Okay. If it's different than that, for the person who's asking that question, go ahead and give us more specifics in the question and answer. And that's all the chats and questions we have right now. So let's move on.
Good. Okay, so intestacy means that you do not have a will. So the law of intestacy everything passes according to state law rather than the wishes of the testator. So no matter how many times you said, I want so-and-so to get such and such, it's not going to happen unless it's just happens to be what the state law says. And I think that the legislature tried to be fair in making these decisions. It goes typically to the closest relatives. The problem being that in many cases, nowadays we have so many blended families and there are stepchildren and to be involved. And if you have a will, it just brings peace to the family because the wishes of the testator are going to be carried out as opposed to the children fighting over anything. If you have minor children, anyone under 18 years old, then you really want to protect them. You need to name a guardian for who would care for them and a trustee for who would manage their finances. They can't inherit until they're 18. And you can put into your will that they're to receive their inheritance when they're 18, or what I recommend is 1/3 at age 25, 1/3 at age 30, and 1/3 at age 35. So if they take all their friends to Reno and blow it the first time, then they have an opportunity to learn from their mistake. The reason that you want to choose your own executor is you know who you trust, and you know who understands you and what your wishes are. And so it's really to your benefit to name someone who is trustworthy to be your executor, and hopefully a second person and a third person to be named after that. So sometimes when a person is elderly spouse, they might not be the best person to be the executor. So that's a family discussion that needs to be made ahead of time. I know it isn't a pleasant choice to have to sit down and talk about dying, but it's the reality that it is going to come to all of us. And you need to talk to your spouse or whoever your significant other is, whoever's going to be named as your executor, and just find out whether they're willing to do this work. So a bond can be required. Typically, people put, if occasionally people do not have any relatives or any friends or anybody that they can name or that they trust to be their executor, so they might name a trust company. And so a bond is typically required if it's an institution as opposed to a person, but you can require it of the person too. It seems strange to me that if you trust the person enough to be your executor, that you would require them to pay a bond to get to serve, to get to do the work for you. But you know, that I just wanted you to understand what a probate bond is. And you can, typically what we put in a will is that the requirement for probate bond be waived. So that's less money for, you know, if the state has to pay for that bond, that's less money for the beneficiaries at the end.
Hey, Kay, we have a couple questions for you. One question is, how do you determine what the payment for the executor would be? And is that just at their whim that the person would write that in their will?
No,
or
no.
Okay.
Yeah, the executor selects the amount. And I recommend that you do a percentage instead of an amount. So let's say that right now you would want that person, that you think that if you died tomorrow, you would want that person to get $5,000, for example. Well, what you can do is take $5,000, compare it to your entire estate, and determine, is that 1% or 2%, 3%, whatever, and put the percentage in. That way, if your assets increase, they get paid more because they're going to have to do more work. If your assets decrease, then they're going to get less money.
Okay, that's great. Here's a great question. Is it acceptable to have an out-of-state executor?
Yes.
You probably see that quite a bit, don't you?
It's inconvenient to them to have to come in to court, you know, have to fly in, but everything can be handled on the phone basically these days. You know, usually there's one initial meeting where you get started, and then make sure that the attorney and the soon-to-be executor are on the same page. And then everything can be, I have one right now. He lives in Florida, and he's going to fly in for there's just one hearing because, you know, it's very straightforward.
And remember the question about the pay on death clause? We have more information. So the bank account is a pay on death clause.
Mm-hmm.
Does that have to go through probate?
No.
Okay. So that just gets distributed
I'm a little
automatically.
hesitant to say no so definitely, because there could be something in the contract with the bank. I don't know for sure.
Yeah,
If I can't
yeah.
see the documents, I really shouldn't be giving any legal advice on that. But in general, I would say no.
Okay. I think we are all caught up on our questions, and so please continue on.
All right. So we've already talked about this a little bit about beneficiary designation form. And what you do is, at the time that you write your will or your trust, I recommend that you contact whoever has your investments and ask them to send you a copy of your own beneficiary designation form so you can see, is it really the person that you want to inherit? If you have a trust, I recommend that you name the trust as the first beneficiary. The reason for that is, rather than it just going to just those people, well, what if those people aren't there? What if they died in the same car accident you did? If it goes to the trust, there are always contingencies, and I put in 3 or 4 levels of, if this person isn't there, then it goes to this person, or it goes to this group. And if those persons aren't there, then it goes to this charity, or it goes to the nearest relatives. And you get to choose all of that. Believe me, if you don't have a will, it costs a lot more to go to court and have a judge make decisions about who gets what than if you don't. Like if you have everything written down in a will. For one thing, you have to hire an ad litem. The attorney ad litem has to investigate in case there are unknown heirs that didn't, since there's no will, they don't know for sure if there were other children. And somebody could come in and challenge the judge later. And the judge doesn't want to say, okay, the money goes to these 3 people, because what if somebody shows up that he didn't know about, another child who was forgotten, or the family didn't know about. And so it's important that you go through all of the proper proceedings in order to not have all of these extra expenses. And if you do have a business, the executor has to close the business unless there's something in the will or trust stating that that business is to continue.
Okay, we have a question for you. When we look at fine art, at what level do you have to list the fine art separately?
Well, that would be part of the furnishings of the house, unless it's a Monet, and then should be named. It should be appraised, and likewise with jewelry, furs, anything. I recommend that you have some appraisal on them.
At what dollar value should you do that? Anything over a certain dollar figure?
I would say, I would recommend anything over $1,000 fine art.
Okay, great. Thank you.
A specific bequest is a statement about who you want to get what. For example, your niece, she always wanted your pearl ring. Well, this is your opportunity to put that in. It can be any of these things, like jewelry, art, heirlooms, collections, furniture. Sometimes people want to give their gun collections to their son, and this comes before the general distribution to the heirs. So you have to be careful about that. Again, if you say, I want to give $5,000 to so-and-so when I pass. Well, what if you've been living in assisted living and you've spent all your money down to where $5,000 is the only thing that's left? Well, your friend might get the $5,000 and your children would get nothing. So again, a percentage is a smart move. So I think we've already talked about the fact that oral instructions don't matter. It doesn't matter what your wishes were unless it's in writing. I can't tell you how many times my clients have told me after we get everything signed, they just say, I feel so much better that I have this done. I know my family's protected. I don't have to think about this anymore. It's not on the back burner in the back of my mind bothering me that I have failed to do this important financial step. So we've talked a little bit about trusts and wills earlier, and I usually recommend trusts to people if they own a home even, because in the long run, if you are, stable in your life and you have a job and, things are going along and everything like that, what happens is if you have a will, each person, let's say that it's a married couple, each person has a will and all the ancillary documents that go with it. And then when this one dies, you have to pay for that probate. And if this one dies, you have to pay for this probate. Well, instead of doing that, you can have one trust instead of two wills and no probate. So trust costs more upfront than a will or even two wills, but it's cheap, much, much cheaper than paying for two wills and two probates. Another advantage of the cost is kept down. So also, at least the trusts that I write are not just Texas trusts. They're good in all 50 states. If I wrote a trust for you or anyone who does a trust that's valid in all 50 states, you can move to Colorado and that trust continues to be valid. You have to get all the ancillary documents done, like your durable power of attorney, medical power of attorney, living will, those type of things have to be written in that state because states do vary from one state to another. But your trust should be valid in all 50 states. And with a trust, you can settle that estate within a month at home with someone who is a professional who can assist you. Whereas with a will, it has to go to court, go through probate, you have the expense and the time. The first thing that's done when a person dies with a will is the will gets filed and recorded with the county clerk. And so it becomes public record and anybody can go in and see who got what. That might not matter to you if you are, let's say an athlete or an actor or someone who's well known in politics in your local area. You don't want just everybody to know who got what. Again, if you have stepchildren, you don't want any resentment coming up in the family because they discovered that so-and-so got so much more than they did. And the federal exclusion tax right now is so high, I've forgotten now, I think it's 15 million per person. Anyway, so, but that could change. When it was only $1 million, it made a big difference. And with a trust, each person gets their own federal exclusion. Whereas in a will, this person dies, their partner inherits that money, and they get only one federal exclusion. So it was very important then, but it's not less important now. That's all. Now, I've been using the term ancillary documents. You may not know what I'm talking about. These are for while you're still alive. A medical power of attorney is the person who you name the people that you would want to come to the hospital if you were unconscious. As long as you can speak, those doctors are going to listen to you as to whether to fix your broken leg or give you a blood transfusion or whatever might be the belief system that you have. But if you're unconscious, if you're in a coma, if you have Alzheimer's and you can't speak for yourself, you want to have a list of people named first, second, third in order again for a medical power of attorney as to who would be able to come to the hospital and make decisions for you medically, whether to give you certain surgeries and so forth. They have to approve of it. And without that, they can't even get into the room sometimes. This is particularly important in the situation where we have gay and lesbian couples, because the family, if you don't have the ancillary documents and you haven't named your partner, what has happened before is that the birth family comes in and they've had resentment against the partner and they won't even let them in the room, much less make any medical decisions. And so if you want your partner to be able to make medical decisions for you, this is a really important one. Likewise, for the durable power of attorney, that's for assets. So they're just two parts of the same nut, two sides of the bread. One is for your medical care, one is for your assets. The HIPAA release is who gets to see your medical records. And so you may or may not want somebody to see that you were in rehab at some time. And so you get to name that and nobody else gets to see your medical records. The directive to physicians, or commonly called the living will, that's the pull the plug one and this is at the end where the physicians have done everything they possibly can to try to save you and you're just down to your last month of life at the most. And what do you want to happen? Do you want to be given the good drugs to keep you comfortable and allowed to die as gently as possible? Or do you want your estate to be spent keeping you alive in that condition? Most people don't. But that's a personal decision, and I don't try to guide people in that. Usually people have very strong feelings one way or the other as to what they want to happen to them at that very end. And you can name who you would want to be your guardian. If God forbid you ever get to that point, let's say you have Alzheimer's, who would you want to go to court and say, see, I have this paper that says that she wanted me to be her guardian.
All right, Kay, we've got a couple questions. This is a great
Yes.
slide. It's prompted a lot of interest from people with their particular situations. And it's good. Thank you for asking these questions, because I think
Yes.
that you are asking questions that other people have and they're just not typing
Yes.
them in. Okay, so the first one is, I am a POA for my mother and I'm downsizing her stuff. Do I have the ability or right to disperse her possessions?
Do you have the durable power of attorney?
It says power of attorney. So
I'm
I'll
not
wait.
sure if I'm assuming she's talking about the durable for assets and not the
Right,
medical attorney.
right. That's what I think too. Mhm.
And her question is, can she
Yeah,
distribute?
she's downsizing her mother's stuff, and does she have the ability or right to disperse her possessions as power of attorney?
Not if her mother can still speak for herself.
Okay. So if her mother can communicate, her mother needs to be the one communicating where those items go.
Yes.
Okay. Another question, is it advisable to have the medical power of attorney living in another state?
It can be handled by phone. The doctors can call and talk to that person. That's a personal decision. Many people feel like they do want to have somebody who is in town to be their number one, and then maybe some of the backups are the people from out of town. But I leave that totally up to my clients because they know who they want to come to the hospital.
Okay. What about a do not resuscitate document? Is a DNR separate from directive to physicians?
Absolutely, and there's a lot of confusion between those, so I'm very glad this person asked that question. DNR, do not resuscitate. If I were to faint here right now and I weren't, let's say I quit breathing, I want to be resuscitated. I do not want a DNR. I don't feel like I'm old enough and ill enough to need a DNR, but I do want to have a directive to physician or living will in place. The DNR is usually for very sick or very elderly people. My mother lived to be, she lacked only 3 weeks of being 105 when she passed away. And so she wanted a DNR after she turned 103. She said, you know, all my friends are gone, my husband's gone. I really don't want to be resuscitated. But
so that is two different documents, and
yes.
It could vary as to why you might need them.
Yes.
Does the cost of preparing a trust vary widely with different attorneys, or is there some kind of established professional standards for those kind of fees?
Say again?
Is there, does the cost for preparing a trust vary widely with different
Yes.
attorneys, or is there some kind of established professional standard for that fee?
There is not. It's supposed to be, quote, reasonable. Well, the Blue Suede Shoe Boys downtown think that reasonable is a whole lot more than I think it is. I heard of a case right here in Austin where it was the grandfather, the father, and the son, adult son, all went in to have their they all had trusts written by this one attorney, and he charged $15,000 for the grandfather, $12,000 for the father, and $10,000 for the son. And they were all the same people in the same family, and he had all the information. So it was not going to take him all that much time. But they paid it because this person had the fancy office and the receptionist and the tile, the beautiful floors and so forth.
So it can vary, and really, you
very
probably want to talk to somebody and find out if you have a good relationship and if they're hearing you. I would think that's really important to have
Absolutely.
good communication. How do we record mom's agreement to disperse items? So we're coming back to that durable power of attorney question. What would you need to have? Do you need to have something in writing saying, yes, I'm okay with you distributing that item?
She just needs to, there's nothing filed, there's nothing legal about it. It's just that the person could be in trouble if they distributed assets that in opposition to what the testator wants, or the
So would
person
you
who
just
wrote
have her write
the
like on a yellow pad, it's okay to give my China hutch to my niece Sylvia and have her sign it? Should she do something like that?
If the rest of the family will accept that, yes, or she might need to tell them. There's nothing in the law about that. It's kind of
Okay.
one of those gray areas.
Yeah. And there's a lot of issues. I see it in my real estate business when we go and we're helping families and somebody has passed and we've got a house full of items and how do you distribute? There's a lot of hard feelings and a lot of family bickering that can happen. So my recommendation always is try to be as specific as possible in what you want to distribute and how you want it distributed so that you can not have so many conflicts with the family.
May I tell a little quick story?
I would love it.
My mom had told, I have 5 sisters. So here are these 6 daughters, right? And so she told each of us, if you see something in my apartment here that you want, just put your name on a piece of masking tape and stick it on the back of the painting or under the chair or, on the bottom of some little knick-knack, whatever. And so when I insisted that I rewrite her will, because she had a 50-year-old will that said everything goes equally to my 6 daughters, didn't even have our names in there, much less what happens. What if one of us predeceased her? Does our share go to the other sisters? Does it go to our children? There was, it was just really bare bones will. So I said, Mom, I do this for a living. Please let me. I'll do it for free. Please let me. She didn't want me to write her will over, but I finally convinced her. So then I said, okay, so now let's go through all of your assets and let's see, who's getting what. And I started taking things off the wall and turning chairs over. Sometimes there were 3 or 4 of these sticky notes on the back. And I said, Mom, you're setting us up for a fight, because if Robin gets it, well, I might let her have it, but I'd resent her, or vice versa.
Yeah.
And so so I made her go through and we did a memorandum that was in addition to her will, and it had every child name and every grandchild name. And that way every grandchild got at least something that was even a bric-a-brac, something that was in her apartment as a memorabilia. And it was more evenly divided among I made her decide. I said, okay, here are 3 names on this. Who do you want to have this? And it was like pulling hen's teeth, but I got her good.
Well, and that helped you all because then you had that guideline and that map that you could follow at her passing.
Yes.
So we have another question about the distribution of items. So what if she doesn't remember items or the people we want to distribute items to? So it looks like we have a capacity issue here.
Exactly. If a person does have incapacity, that's a different story. That's exactly what the durable power of attorney and medical power of attorney are for, or once that person is considered incapacitated. The problem is what if one child thinks that their parent is incapacitated and the other doesn't? Well, then the one who thinks that they're incapacitated, they need to take them to a specialist who can give them a test to state, legally this person is incapacitated. Then definitely these powers of attorney kick in.
Excellent. Thank you. That's all the questions thus far.
Okay, these are upon death. The other ones that we were talking about are for while you're still alive for your own protection. These are upon your death. So organ donor information, and the one that I use is much more detailed than just yes or no. It can be a certain organ that you want to donate to a certain person. For example, if your sister is on dialysis, and you would definitely want, if you were to die, you would want her to have your kidney, that kind of thing. And then the other document is the appointment of agent for disposition of remains. And I believe they've shortened that now. The legislature just shortened it down to appointment for disposition of remains. But this is the person who would see to it that your wishes are carried out for your funeral or your memorial service or burial or cremation, and it prevents disagreement in the family. Because what if, mom always told me that she wanted to be cremated. Well, that's against my religion, and the fight is on. But if it's in writing and mom wanted that, people are more likely to go along with it. These are some reasons to update your will or trust. So if you already have a will or trust and you want to get that out and look at it, these are some good reasons, and hopefully it will spark you to review your will or trust, which should be done every 2 or 3 years. What if some of the people that you named in your will, usually parents or children, you named them in the will to either inherit or act as your agent, act as your executor, and they have predeceased you. Or perhaps you've had more children born to you, or you've adopted children, or you want to give gifts to your grandchildren and you want to name them. So you want to get that out and look at it. Perhaps you've remarried and there are stepchildren involved now, and you really like these stepchildren and you really want to give them something, and you didn't even know them when you wrote your will or your trust. So it's good to get it out every couple of years and look at it and make sure that it's still serving you. You have to think of a will or trust like a new car. It's sitting in the garage. It's exactly what you want. You're so thrilled with it. But things change. The tires wear out and life happens. And so you have to be flexible about it. Another reason is if the value of your estate is either increased or decreased. And so you have the opportunity to change your will or trust and I don't think I told you that just like a codicil on a will, the terminology used with a trust is a trust amendment. If it can be a partial amendment where just 1 or 2 things are changed, or it can be a complete amendment where the whole trust is completely rewritten, but you keep the same name of the original trust, the same title. You might want to make a gift to some charitable organization that you've gotten involved with. Or perhaps you do want to add a family member, or you want to exclude a family member from ever inheriting. Somebody has acted up and you do not want them to be able to get any of your inheritance. And so you have to review that and see what's your life like right now. So when do I need a will or a trust? These are some of the frequently asked questions that I'm going into now, and perhaps they'll answer some of your questions that you've been holding, or perhaps not. Well, I have 11 questions that I'll run over very quickly, and then if you have questions, then we'll take them from the attendees. So when do I need a will or a trust? Well, you know what? Everybody needs a will or a trust. That's all there is to it. Even if you're living in an apartment and you just have your furniture and your clothing and not very much, it can't go to anybody unless you have a will. And if you don't have a will, the state will write one for you, and it winds up being more expensive to go to probate. Well, we've already talked about the charitable organizations. And especially if you want to give something to a friend, they're not going to get anything if you don't have a will. So if you have a will or a trust when you die, there are some major advantages. So you can select your child's guardian, for example, if there's no surviving parent. You can avoid a lot of family fights that happen. I've heard people say, well, I'll be dead, I won't care. Well, I think you care whether your family is at each other's throat and has a lot of division and never speak to each other again. You never know a person until you share an inheritance with them. It's incredible what it does to some people. Some people care so much for assets that they're blinded at that time. Plus, they're going through grief. And you can control the cost of probate by waiving the bonds and stating the amount of payment to the executor. And you can, if you do have a family business, you can ensure that continuation. So how do I change my will? So we've already talked about this being the codicil on a will, and on a trust, it's called a trust amendment. But if you do that codicil or will, you can't just scratch out, let's say, instead of Susie Q getting this, I want Billy Bob to inherit. Well, you can't just cross that out and initial it and put somebody else's name in. It has to be changed with the same formality as the original will, which means it must be signed before a notary and at least 2 qualified witnesses. And you cannot initial or write in changes. What will happen is the judge will read it the way that it was originally written. So you have to, rewrite it correctly and do it legally. So often people will have a will or a trust and it's lost at the time they die. They've put it in their bottom drawer and they know where it is, but nobody else does. So it's really good to keep the originals, because the original has to be filed if it's a will with the court. But even with a trust, keep your originals in a bank safe deposit box, a home safe, or a fireproof box. And then if you give copies out to anybody, agents you've named on any of your documents, your executor, whoever, that's fine. But then if you ever change those wishes, you have a new will or a new trust, or a trust amendment, then you have to go back and get those documents back from those people. So you should keep track of who you gave copies to. This is a common one. I wrote my will so long ago that my ex-husband was named in it, and I don't want him to inherit anything. Well, the court will treat it as if he died before you did, so he won't inherit.
Yeah, I got a question for you.
Yes.
What if you want to change the will and she's in a nursing home and she has memory loss?
Once she has memory loss is on a continuum. So let's say she doesn't know who her children are. She doesn't know what she owns, what can be inherited. She's too far gone to rewrite anything, will or trust. But let's say that in the morning, she's really bright and cheery and sharp and able to make decisions. If she has the capacity to be able to go out and buy a car, her knowledge and understanding is enough that she can go out and purchase something like that, then she has enough capacity to make any changes that she wants to make. Does that answer the question?
She's physically incapacitated.
Well, physically is different than mentally incapacitated.
The first question was memory loss, which I think you answered,
Yeah.
but physical incapacity and memory loss, she has both.
Well, it sounds like she's extreme. Again, I can't say, since I don't know where she is on that continuum, and I don't know if she's been tested for incapacity or not. I would be hesitant to give any kind of legal advice.
Okay. Thank you.
Mm-hmm. I have a case right now that's very interesting. A man wrote his own will, and he considered it a holographic will, but he typed it. If you type your will, it has to be signed by 2 witnesses. If you write a holographic will, it must be totally in your own handwriting, And therefore, someone can come to court and testify, yes, that was her handwriting when it goes to court, when it goes to probate. So the person, and there's certain requirements to write a holographic will, to write your own will. You must state something that, there are no specific words you have to use, but you have to indicate that it is intended to distribute your assets. And you don't even have to say it's your last will and testament, but it's smart to go ahead and include that. It's not required to put the date, but you must sign it in your own hand. And the whole thing has to be in your own handwriting. And it's, if you want to name an executor, you can. Sometimes people write holographic wills just in the meantime until their lawyer can get their will or trust completed, because they're, like in the pandemic, I've had people writing their own holographic wills while they're waiting for me to get myself in gear and get their will or their trust finished. I'm just piled up with work is the problem. Okay. So we've already talked about this. They're called interlineations, where some little old lady has crossed out somebody's name and put somebody else's name in, and the judge will read it as if that those interlineations are not there. So, you know, they would have been disappointed if they knew that that person that they wanted to inherit did not inherit. Yes, you can go on LegalZoom, you can go to a store and you can get online wills. The problem is that it usually comes back to bite you in the butt, because they're not Texas specific. They don't have words like independent executor in them. They ask you questions that you don't know how to answer because it sounds ambiguous to you, and you might write it in a way that's not clear. It winds up costing a whole lot more at probate, because people can be arguing over the meaning of things if it's not written correct legally. So what happens if I die without a will? Well, I think I've already told you several times, the state of Texas is more than happy to write a will for you. They don't actually write out the will, but it's in the law as to who gets what. And it's usually the closest relative. But did you know that in a situation where perhaps the husband had a child from a previous relationship and the wife wants to probate his will, he doesn't have a will and she has to go to probate, she winds up owning half her house and that child owns the other half. So especially in situations like that, it's really important to have something stating all goes to my wife. And if they say that, if they're giving their share to the wife, because in community property, she owns half, he owns half. And so all she gets is her share when he dies, if there was a child from a previous relationship. And that could be very difficult because one might want to sell and one might not. So a living trust, yes, it can save you money because of avoiding probate, is all this slide says.
Hey, Kay, we've got a question.
Yes.
The question is, my adult daughter is my durable power of attorney. Her name is on my bank account. The bank has asked for a copy of the POA. Do I give it to them?
Say it again.
So my adult daughter is my durable power of attorney, and her name is on my bank account. The bank has asked for a copy of the POA. Do I give it to them?
Yes, there's nothing wrong with you giving it to them.
Okay, great. And that's all the questions I have thus far.
Well, that ends my questions. If we have no other questions, I guess we're finished.
All right, guys, let me give you one more chance here to put a question in the chat or to put a question in the question and answer area. You can do it in either. Do I have to do a new will if I move to another state? I think you answered that.
Yes, definitely. Definitely. Wills vary from state to state. A trust can be valid in all 50 states if you have a certain kind of a trust.
Okay. And I'm just checking all my questions and answers in my chat. I don't see any others at this time. So, Kay, we just want to thank you for coming on your first Zoom call presentation. How fun for you. You did an excellent job. Super informative. It was really easy to understand what you were saying, which I really appreciate because sometimes your eyes just glaze over. So Thank you for such a great presentation. We look forward to seeing everybody on Thursday at the Shred Day. Remember, we're looking for donations, but if you can't do it, we totally understand. And then we'll see you next Monday, where our topic is going to be aging in place. Everyone have a great week, and thank you again, Kay.
You're welcome.
Bye.
Bye-bye.
Bye.